So good afternoon and welcome to today's webinar. It's hosted by the Georgia chapter of HFMA. I'm Laurie Heavey. I'm a Georgia HFMA Education Committee volunteer. Here are some reminders before we get started. I want to give you some reminders about activities we have going on before we close out the year. And top on the list is our virtual Give Back Challenge. This year, the dates are this coming weekend, November 20th and 21st, and again, December 11th and 12th. And rather than being in person, what we're asking is that you be creative in ways that you can give back to the community and then document that on our Georgia HFMA social channels with the hashtag HFMA Gives Back. Hopefully you've been getting the emails from Georgia HFMA about that. Some ideas include dropping off monetary gift cards to a local shelter or food bank, or maybe even organizing a neighborhood food drive for the holidays. Another idea is buying a cup of coffee for the person behind you in the drive-thru at Starbucks. And now more than ever, we should all just take a breath and be kind and give to one another. So I wanted to remind you about that. And then also on this theme of giving, the Georgia HFMA is still looking for volunteers as we move into 2021. We have lots of committees that you can be part of. And even in our virtual environment, we've stayed connected with our membership, and it's a great way to network and remain involved in the industry. Please do check the Georgia HFMA website under the Get Involved tab. Before we get started, here are just a few housekeeping items. All of the phone lines are on mute to avoid interruptions during the broadcast. Please submit your questions using the question box at any time as you have them, as you think of them. Just go ahead and put it in the Q&A box. I'll be monitoring that for Lori and Kyle, and they'll get to those questions at the end. And also, we'll be providing the presentation, the recording, and the links for the survey and CPE credit. You'll receive all of that in email probably Friday morning. It will come from me, Laurie Heavey, and my email address is lheavey@clearbalance.org. So be on the lookout for that. As I was mentioning, everybody on today's call is eligible to continue to receive continuing education credits. So again, be sure to be on the lookout for that form. And finally, before we get started, I'd like to take a second to recognize and thank our chapter sponsors. You can see their logos on the screen now. We very much appreciate your support. Today, our speakers are from Aspirian Health Resources, Lori Lepaki and Kyle Fisher, and they're going to be telling us what not to do when it comes to MVA and TPL collections. Let me first give you some details about their experience. Lori has over 14 years of experience working with medical providers on reimbursement issues and 16 years of property and casualty experience as a casualty claims manager for Allstate. As president of Aspirian Health Resources, Lori oversees an organization that's focused on investigating and processing complex claims such as motor vehicle accident, premises liability, workers' compensation, and veterans affairs claims for over 120 hospital and physician groups across the country. Kyle Fisher is general counsel for Aspirian Health Resources. He has more than 10 years of experience negotiating hospital liens on both sides as a personal injury plaintiff's attorney and a hospital attorney. Kyle spent his first 7 years as a military attorney in the U.S. Army JAG Corps, serving in Seoul, South Korea, and Fort Benning, Georgia, where he was the Martin Army Community Hospitals Triad Counsel. As an attorney licensed in Florida and Georgia, Kyle has litigated cases ranging from a multi-million-dollar class action against a predatory lender to criminal defense to hospital lien enforcement, which has allowed him to develop a keen insight into how a person or organization's actions are going to be viewed by a judge or jury. Kyle has served as Aspirian Health Resources retained counsel since 2012 and joined the Aspirian team as general counsel in 2018. Lori and Kyle, we're ready to begin.
Thanks, Laura. So thank you everyone for joining us this afternoon. So we're going to cover some of the things to avoid in your MBA program and try to provide you some information, also give you an update of what's been going on here in Georgia with regards to some recent case law that may have impacted how our lien statute has been interpreted. So we appreciate you all joining us today. Just a little bit about Aspirian. As Laura mentioned, we focus on the complex portion of your revenue. It's usually about that 10% of the difficult, messy stuff. Claims like MVA or work comp that have a legal element. There are complicated claims like VA or denials, Medicaid services, aged AR. We did begin as a law firm here in Georgia, and our corporate headquarters are located in Columbus, Georgia, and we have locations in Missouri, Florida, and in New Jersey as well. So I'm going to start today just by kind of just going over with, to let everyone know what happens after an accident. Hopefully most of you have been very fortunate. You've never had to be involved in a motor vehicle accident. I think just based on my career and the different jobs I've had, I have been on literally every side of the settlement process, as has Kyle. Whether it was on the payer side with Allstate, on the personal injury side as part of the law firm, or even as a mediator trying to achieve resolution on these claims. So typically what happens, once the accident occurs, the patient goes in for treatment. A lot of times he's going to arrive by ambulance in your emergency room. Sometimes patients don't have treatment right away. They don't realize that they're hurt, or someone tells them how they need to call an attorney, and the attorney says you need to go get checked out, you need to go get treated. So they may show up the day or two after the accident. But most of the time they are going to come in via ambulance into your emergency room. So once they receive medical treatment, typically they're sitting home the next day. If they're watching television, we've all seen, if you're watching the morning news, the most frequent advertising in the morning are going to be different law firms advertising for those personal injury cases. So a lot of times that patient thinks, well, my car's in the shop, my neck hurts, my back hurts. So he's going to pick up the phone and call the attorney. The attorney will send someone out to sign him up. They'll enter into an agreement where the attorney is going to represent the patient. And then, the attorney is going to have the patient continue their treatment. And then once the patient has concluded their treatment, the attorney will start preparing all the documentation he needs to try to make a settlement demand against the other party. So part of that settlement demand will include the medical bills and the medical records. If there's wage loss, they'll provide some information from the patient's employer as to how much time they've missed from work. And so they'll combine this into a letter, they call it a demand letter, where they're sending it to the insurance company for the at-fault driver, and they're making a demand for a certain dollar amount that includes payment of all these medical bills and also an amount for pain and suffering. So once that demand package is received by the liability insurance company, then they're going to evaluate the claim. They weigh heavily on the amount of the medical bills and actually the documentation in the medical records as far as how much treatment was required, how long did it take the patient to recover, and then they will evaluate the claim and make an offer back to the patient's attorney, and then those negotiations will begin, and then eventually they'll come to an agreement. Most cases do settle without going to an actual trial. Probably about 95, 96% of them will settle without having to actually go into a courtroom to reach a resolution. And so once the claim is settled, then the payment is made to the attorney, and then he will take his share of the settlement proceeds and will pay the remaining balance to the patient. Now, if the hospital has not filed a hospital lien that attaches the settlement proceeds, then when they're distributing the funds from the settlement, a lot of the attorneys will leave it up to the patient as to whether he wants them to pay outstanding medical bills or if he just wants to receive the money. Most of the time, the patient, once he receives his share of the settlement, he doesn't hop in his car and drive over to the patient financial services office of the hospital and pay his bill that he received from the accident a year ago. Quite often he's already had his credit flagged, or he's gone through the collection process, and he's really not motivated to make sure that his outstanding hospital bill gets taken care of. So if you don't have a hospital lien in place, then that's typically what's going to happen. It's pretty rare that you're going to have a patient voluntarily come in and pay the medical bills out of his share of the settlement. But if you file the hospital lien, then that lien will attach to the settlement, and that may give you some type of recourse back in order to collect for your outstanding bill. So we're going to kind of cover what happens as part of that process and some things that we would recommend that you try and avoid. So when you're talking about liens and liability coverage, most hospitals refer to this segment of your revenue as TPL or third-party liability, and that is an important element, and that is a good way to collect on some of these self-pay claims where there really is, the patient doesn't have any other ability to pay, and there is a third party that's going to be responsible. Just like I mentioned in that settlement process, when the liability carrier is evaluating, how much they should pay that patient to settle their claim, they're going to consider the medical bills, and the medical bills that they've been provided are the total bill charges. That's what the attorney is going to collect. They want an itemized bill, and they're going to provide that as part of their demand. So this is a way that you would be able to get compensated for the care that you've been providing if you've got that hospital lien in place, and the only recourse for you is from that third-party liability coverage. But as we're going to talk about today, that may not be the best choice, and it's usually not the only choice. But to circle back around and talk about liens and liability coverage, all the hospital lien that we're talking about is a legal filing that secures payment of medical bills from a liability settlement. The reason you file it, it is the only way that you will receive payment from that settlement, the only way that you can try to, guarantee that you'll receive some payment if a settlement takes place. As far as when should it be filed, if the patient is uninsured, or in Georgia, if they have Medicare or Medicaid, it is the provider's choice to pursue liability for what should be a higher percentage of reimbursement instead of going after the governmental payer. Or if the patient has commercial insurance and there's a high patient responsibility after that insurance is paid, maybe they had a high deductible or they had a lot of co-insurance, then you could file a lien after the commercial health has processed. And you do want to file it as quickly as possible so that you get your lien there in place before any settlement can occur. As far as how much recovery can you expect from a hospital lien filing, well, it does depend on the factors of the settlement. We typically see an average that runs between 70 and 80% of total bill charges, in a lot of the markets that we service. So what happens if they ignore the lien? You usually do have a recourse in just about every state to pursue recovery. If your lien was filed properly, you do have a certain time window that's available there to try and enforce settlement of or payment of the lien through a litigation process. In Georgia, that time limit is 12 months. So it's 12 months from the date of the settlement, whether the hospital is aware of the date that the claim settled or not. That 12 months starts, counting from the moment that the settlement is agreed to between the patient and attorney. So those are just some important things to remember. So before we get into the 5 mistakes we want you to avoid, a lot of people wonder why they should even bother with an MVA TPL collection program. Because we feel strongly that if you have a good program in place, whether you're doing it in-house or you're partnering with a vendor, to have a really good program can benefit both the provider and the patient. So the benefits to the provider are that you're going to get an increased cash collection. So if you have a program, you're going to identify maybe some other insurances out there. They're going to help you get the claim paid, or you'll have a sound program to use your hospital liens, or have a good program in place for third-party liability collections. And one of the reasons that this is beneficial is that typically when those coverages are available, whether it's a first-party coverage on the automobile policy, like medical payments coverage or personal injury protection, quite often you can collect up to 100% of the total bill charges on some of those claims. Or if you're going after third-party liability, again, the reimbursement rate is going to be in the 70 to 80% mark. You compare that to the self-pay rate of collection. I think the last statistic I saw on that nationwide, it was about 6 or 7%. Or even if you're comparing it to what you're collecting from Medicare or Medicaid, you're probably in the low 20% range on those. So it can definitely make an increase in your cash collection if you have a good program where you're really seeking out the availability of these coverages and you have a program in place to file your claims. We do know one of our facilities, on their own, they were doing only about $8,000 a month. And then after 12 months, when working with us to try to get a program in place to both identify the medical payments coverage that might be available to the patient and also to make sure that the liens were being filed appropriately. That $8,000 increased to about $348,000 on average per month. So it can definitely make a big impact if you don't already have some type of program internally. We do see a lot of hospitals that typically just make these accounts self-pay and put it back on the patient, and that doesn't usually end up being very effective. The other benefits to the provider by having a good MVA program is that you can also identify your coordination of benefits opportunities and be able to manage that more effectively. A lot of commercial health contracts will make automobile insurance primary, and if you don't have a process in place to help you go in and identify whether the patient has medical coverage on their automobile insurance or not, and you're relying on the patient to provide that information back to his Blue Cross or whoever his commercial health may be, then a lot of times, those claims will just be stuck there kind of in limbo and you won't actually receive the reimbursement. Medicare in particular requires that medical payments and liability be billed. If you haven't been paid within the 120-day conditional payment period, you can then file for your conditional payment. So there are some requirements from some of these other insurances. And it's very helpful. You can meet those requirements much more effectively if you do have a good program to try to determine whether or not some of this coverage exists on your own instead of relying on the patient to provide the information. The benefits to the patient is we feel that if you've got a good program, it can enhance the patient experience. So a lot of times when the patients come into your ED, they really don't know the process. They, are upset. They don't want to give you their health insurance. They don't want to give you their automobile insurance. They're mad at the person that hit them. They think that that person needs to pay all their expenses and they don't want anything to come out of their own pocket. So they really don't understand how some of the coverages on their own automobile policies work, and they may not understand the fact that, even though that other driver may clearly be responsible or may be at fault, and he may have liability insurance, that liability insurance is not going to pay the medical bills for the patient as they're incurred. They're going to have to wait for that settlement to occur, and on average, it's about 280 days here in Georgia is what we see. So again, a lot of times the patient really doesn't understand the process. So if you've got a good program in place and you've educated your patient access resources so that they're able to at least provide some basic information to the patients on how the process works in your particular state, it definitely can be beneficial, and you can set the right expectation, for that patient. We actually believe that a hospital lien is a patient benefit because the liens do only attach the potential settlement, not the patient's individual assets. And it allows the hospital to put the account on hold while the settlement process runs its course. So the way we explain it to the patient is that, yes, we're going to file a lien, which will allow you to have time to settle your claim with the at-fault party. And at that time, the hospital bill can be paid. And since we filed the lien, that will eliminate you from going through the normal collection process. So we do feel that you can explain that in a way where, again, it's considered a patient benefit, and we're setting the right expectations for the patient and they kind of know what to expect. So we do realize that it's not always easy to set up a really good program for your MVA and your premises liability claims. You do need to have some specialized knowledge in both the property and casualty insurance coverages and how those coverages can work. The fact that you can stack some of them together for more coverage, because again, your patients are not going to know either. It's just not something that if you've never had the misfortune to be involved in a motor vehicle accident, you may not really know what coverages are on your policy. Whenever we do training for patient access classes, we typically ask the class, how many people in the class know whether or not they have, medical insurance on their automobile policy, or how much coverage do they carry on their insurance policies. And typically more than half the class doesn't know the answer to those basic questions. And our patients are kind of the same way. They really don't understand. So you do need to understand more because you can't really rely on the patients to know. You do need to be aware of any state-specific legal requirements and processes. Quite often, you're going to need legal support, whether it's creating your lien document or signing the liens. You want to make sure that they're done correctly and that they're going to be enforceable. Sometimes when you file liens, if you're not willing to take action when the attorneys and the patients ignore your lien, then that kind of negates the whole process of, or the effect of having a lien program. And then sometimes when you can't reach an agreement on, how much should be paid to satisfy the lien, you may end up with a court action called an interpleader, where the patient's attorney is filing it with the court so that the judge can divvy up the settlement proceeds. So you do need to have some legal support available to you in order to have an effective program. There are also some costs associated. The biggest one is probably in your FTE resources, because investigation, lien creation, submitting paper claims, negotiating payment amounts and follow-ups are very labor intensive. So they do require a certain amount of resources in order to be able to complete those functions. You also have costs for accident reports, filing fees for liens, legal costs, etc. So it can be costly. And there is a relationship between the aging of this part of your revenue and the collections. When you're filing liens, they do age longer. Typically, as I mentioned, it seems to be the average settlement time in Georgia hovers around the 280-day mark. So they do age longer than your typical claims in your revenue cycle. So that is something that you wanted to expect. But again, if you remember that, you do have a high success rate on your lien filings, and you also have a pretty high liquidity rate on that collection, with it usually running between 70 and 80%. There's also the risk of class action exposure if you're not handling these claims appropriately. And usually we see this because someone's gotten overly aggressive and trying to go over that higher reimbursement. And I know we're going to talk about some of those risks and how to mitigate them in our presentation today. So now we're going to go into the top five most common mistakes to avoid in your TPL programs. And these are some things that we've encountered as we worked with different hospitals across the country that either were doing it on their own, or maybe they were using a different business partner to manage it, and they were running into some issues. So these are just our recommendations on what you want to avoid in your program. The number one item that we see most often is that the programs are designed to only pursue liability coverage, that third-party liability collection. But I can tell you that liability coverage is not the only source of payment available for accident-related medical expenses, and quite often it's not going to be your best choice. There are other insurances on automobile policies, and as far as what those coverages will be and whether they're required or optional will depend on which state where you're located. There are two basic types, and we refer to these as no-fault medical coverages because you do not need, it doesn't matter who was at fault for the accident. You don't have to make a determination of liability. So there are two types: medical payments and then personal injury protection, which we refer to as PIP coverage. So they're very similar. They both work primarily the same way. They're not fault-based. Quite often they're going to be primary to other health insurances. There's usually a high reimbursement rate up to the limit of coverage. Multiple policies may apply, especially when you're talking about medical payments coverage. Usually when we see medical payments coverage, it's going to be an optional coverage. That's what we have here in Georgia. So in Georgia, you have the option of purchasing medical payments coverage on your automobile policy. You're not required to purchase it. It really depends on your insurance agent as to whether he considered it part of full coverage on your policy or not. And quite often we find that patients don't really know if they have this coverage on their policy or not. The advantage of medical payments coverage is that you can have more than one policy will apply. If Kyle's riding in my car and we get into an accident, I have $5,000 of medical payments coverage with State Farm. Kyle has another $2,000 of medical payments coverage on his policy with USAA, which that means that for his bill, he's going to collect, he's in my car, he's going to get my $5,000 first, and then he's going to get his own $2,000. So he's got a combined amount of $7,000. So you can't have more than one policy that will apply, especially if it's a medical payments policy. These coverages typically pay quickly, especially when you're comparing them to the third-party liability collections. And they also extend to all vehicle-related injuries. So it's not just one car, crashing into another car, or what we typically think of as a motor vehicle accident. Injuries that may occur to the patient while they're getting into or out of a car. Someone closed their hand in a car door, or they're loading or unloading the car. The hatchback on the car came down on their head and they've got stitches now on their scalp. Or they're maintaining the vehicle. They got hurt changing the tire or working on the transmission. Anything that is related to owning and maintaining a vehicle could be covered by the medical payments coverage. And so when we talk about personal injury protection, this is typically what you see in states like Florida, New York, New Jersey, Michigan, where you're required to carry medical coverage on your automobile policy. So they normally provide that in the form of personal injury protection. And whenever it's mandatory, quite often there will be a fee schedule associated with it. The difference between medical payments coverage and personal injury protection is that the PIP coverage also includes coverage for wage loss. So while that's beneficial for the patient, it also kind of reduces the amount of money that may be available there to pay the actual medical bills. And the other restriction with personal injury protection is that the patient is out of their home state. They have to be in their own vehicle in order for this coverage to follow them into another state. We typically see a lot of patients coming from New York, New Jersey, or Florida, as we have the snowbirds that kind of go back and forth during the year. And a lot of them have to go right through Georgia to get to where they're going. So it is quite common that Georgia hospitals will see patients coming in that will have personal injury protection coverage available to them. So the first party coverages are usually, that's where we recommend that you always start when you're to look for those medical coverages before you automatically just think about filing a hospital lien and going after the liability coverage. Liability is another type of insurance, and this is where you need those liens in order to be effective in collecting from this type of coverage. They call it third party liability because it is insurance that you pay for on your insurance policy, but it's going to benefit a third party if you're responsible for their injury or their vehicle damage under the law. So liability coverage is mandatory in most states. It is mandatory here in Georgia. The minimum limit is $25,000 per person, $50,000 per accident. You can have more coverage than that, but that is the minimum requirement here in Georgia. Again, you do have a higher reimbursement rate on these claims, but you must wait for the settlement to occur. They will not pay medical bills as they're incurred. They're only going to wait and then make one settlement, including all the costs of the medical treatment that the patient has had. And so that is one of the problems with just relying on liability coverage. You do need the lien filed. If you're in a state that doesn't have a hospital lien statute, you can use a letter of protection. And then typically the patient's attorney is going to want to try to negotiate the amount that is paid to satisfy the lien for those medical bills. Uninsured or underinsured motorist coverage is just another form of liability coverage. It's not always attachable by your hospital lien, but it is good to know if there's additional compensation available to that patient for their settlement. It'll help in the negotiation of the lien against the liability coverage. So here's just a quick example just to kind of give you an idea of how this coverage could work. So if you've got, so John Brown and Betty White are friends who are traveling together in John's car. Bill Black runs a stop sign and hits John's car. All three are injured and taken to the county hospital for treatment. John Brown's bill is $4,800, Betty White's is $6,800, and Bill Black has a bill of $6,200. John and Betty each hire an attorney. So they're going to plan to pursue a settlement against Bill Black's insurance. Betty has no other health insurance. John has a policy with Blue Cross Blue Shield, and Bill has Medicaid. So what should happen when you look into what the available coverage from automobile insurance? So let's say John has $2,000 in medical payments with Allstate. Betty has $5,000 with medical payments with Geico. Bill has $5,000 in medical payments with State Farm, and then Bill has a $2,550 liability policy with State Farm. So as far as who should pay, For John, Allstate should pay the first $2,000 of John's bill from the medical payments coverage, and that $2,800 balance would be billed to Blue Cross Blue Shield. The $2,000 from John's MedPay should be applied to any patient responsibility first, and then the balance billed to Blue Cross Blue Shield. For Betty, Allstate should pay the first $2,000 of Betty's bill from John's coverage. Then Geico would pay the additional $4,800 from Betty's own policy. And then for Bill, who had $5,000 in medical coverage with State Farm would pay $5,000 of Bill's $6,200 bill. So the benefits to the provider and the patient, John's bill is paid in full between Blue Cross Blue Shield and his MedPay, leaving no patient responsibility. Betty's bill is paid in full between Allstate and Geico. The provider received 100% of the bill charges and did not have to pursue patient collection or file a third-party liability lien and wait for settlement to occur. And for Bill, so Bill is the at-fault driver, but so $5,000 of Bill's $6,200 a bill is paid. So the reimbursement to the provider is significantly higher than what would have been collected if the bill had been filed with Medicare. And so there's no additional payment needed from the patient. So all this has been a product of the medical coverage available on the auto insurance policies for this accident without ever having to get into that third-party liability and having to file a lien or wait for the settlement to occur. There are other types of payers available on other insurances. Homeowners and renters policies have a coverage called guest medical that works similar to medical payments coverage. They also have liability coverage available for injuries that occur that may be the responsibility of the homeowner or the renter. Recreational insurance policies, that's in coverage on your boats, your campers, your RVs, hunting mules, four-wheelers. The recreational insurance policies also have liability coverage, and they also have medical payments coverage. Travel insurance is another area that you should look at, because if you're purchasing an airline ticket or a train ticket, or you're booking a cruise and you buy travel insurance, that travel insurance does provide a high level of medical coverage. So you can, that is another area to look for to collect, especially if you're dealing with a self-pay patient. And then commercial premises liability, that's where a patient comes in and they've slipped and fell at Walmart, or they got hurt at Home Depot, and so they have a liability claim back against Home Depot or Walmart or wherever the business is. There is no medical coverage available by these businesses. This is strictly a third-party liability situation, but it's good to know that there could be the potential for collection there. Here are some examples of where we've some recoveries that we've had recently. And some of these cases, like this one particular one, the $130,802, that was one of our Atlanta hospitals where this was treatment in February that was actually related to a motor vehicle accident in 1975. And as part of the settlement conditions for 1975 and the insurance that the patient had available to them, the benefits were still being provided 45 years later. We've had situations where medical payments coverage paid a bill in full of over $24,000, where the patient was actually working on his motorcycle while it was on a lift and it fell on him. And so he had fairly extensive injuries that were all covered by his medical payments policy on his automobile policy. We've had homeowners policies that will provide coverage for four-wheeler accidents in certain situations. Travel insurance, we collected $92,000 for a patient who fell on an Amtrak train. We've had a car accident where the MedPay, there was $100,000 in medical payments coverage, and they paid the bill in full of $83,243. We've had situations where the house or the car came into the house and injured the patient. We've had a lot of snowmobile accidents in our Colorado and Washington state facilities. Those recreation policies typically carry $10,000 in medical payments coverage, and so we've had a lot of those. Those snowmobiles apparently go fairly fast, and so whenever we see accidents coming in, usually we're going to exhaust the coverage available to try to pay them the larger bills. We actually had a holiday party here in the Columbus area where the deck collapsed, and then we had a lot of patients that had foot and ankle injuries, and we were able to get those paid through a homeowner liability policy. So those are just some of the examples as to why you don't really want to just focus on liability coverage. You want to look at other medical coverages that may be available on these property and casualty policies. The next mistake that we see is sometimes we'll go in and we'll be meeting with the hospital to do an assessment, and they'll tell us that they've been filing, their own liens. That they've set up a program and they've been filing them for several years. And so, but one of the things we find out is that they file them, but then they don't do any follow-up, or they don't manage them, after the liens have been filed. And so that is one of the problems that you would see. I know we brought in a hospital and they had liens. When they turned over their inventory to us, we saw liens that went back about 7 years. And so we asked them, we said, do you have a problem? Do attorneys ever just ignore your liens when you file them? And they didn't think so. They really weren't aware that that was happening. But on a lot of those aged accounts, we found out that over 80% of them were not collectible because the cases had already settled, and they had settled more than 12 months before. And so there was really nothing that we could do to try to collect on them. So it's very important to do follow-up, if for no other reason than to know when settlement occurs. Because once that settlement has occurred, as I mentioned earlier, you only have 12 months in order to file litigation to enforce lien payment. Now, I say file litigation, you very rarely have to resort to actually filing litigation. We send a 24-hour demand once we find that the settlement has occurred and that the hospital lien was not paid. And then we send a little stronger letter giving them 5 days to pay. And typically, most of them will go ahead and pay the claim, even if it means they're paying it again, or they're paying it twice. And there are some times if they feel like the lien was not appropriate or not valid, they may dispute it, and we may actually have to proceed to actually filing litigation, but that doesn't happen all that often. If there's no settlement, you're not going to get a payment from the lien, and so you need to know that earlier than later so that you can then move the claim to patient responsibility. So what happens is the patient comes in, he's mad, he calls the attorney, the attorney signs him up, the attorney wants him to go to this physician or that physician, but the patient's feeling better, his car gets repaired, and he decides he really doesn't want to fool with it, he doesn't want to, pursue the settlement. So he stops, either stops cooperating with his attorney, or, he loses interest and the case gets closed. If that happens, you really want to know that, so then you can make it, move it to patient responsibility and not have it categorized there as something that you've got that lien sitting out there. Because if there's never a settlement, then the lien's not going to be worth the paper it's printed on, because there's nothing for it to attach to. The other thing is that, having a good follow-up program could have an impact on your AR days. We've tried various things to try to reduce the number of days it takes to get paid from a TPL lien. We found that really the only thing that kind of moves the needle is if you involve the patient in the process. Because if you're just making a call to the patient just to check on the status of their settlement, a lot of times that will prompt the patient to then make a call to their attorney and try to get the process moving. So we do recommend that you classify these accounts appropriately in your system. You don't want them to automatically refer out to bad debt. And we do recommend that you have a financial class or agency code so you can sort of separate your liens from your other aging. So the next mistake that we run into is we see that sometimes hospitals have unreasonable expectations in terms of what they're going to recover from their liens, and they have what we consider unreasonable negotiation tactics. So we have had hospitals that when we first engage with them, they don't want to give any discount off the bill and to satisfy the lien. So they just kind of have a hard line on it. They feel they provided the treatment, that the hospital should be paid before anyone else. But unfortunately, that's not how the lien statutes are crafted. Attorney fees take precedent over any other involved party. So, and $25,000 is not a lot of coverage there when you're trying to pay the attorney, and you're trying to satisfy the patient, and you're also trying to satisfy the medical expenses that the patient's incurred. And so if you can't negotiate it and come to an agreement on your own, and you reach an impasse, then you're going to usually end up with a legal action, which means a judge is going to be the one making the decision as far as how he's going to distribute, the settlement funds. So a lot of times we're asked, how do you know what's the right amount? We recommend that you have to really look at each case on its own merits. You do want to make sure you know the facts of the settlement, how much coverage was available. Are there other medical expenses? Did other medical providers file hospital liens as well? What's the patient's condition in recovery? Have they recovered fully? Are excuse me, are they going to require ongoing care? Has the attorney, reduced his fee? What type of fee is he collecting from the settlement? And the other thing that we always recommend is that you don't assume the patient's attorney has exhausted all the avenues of payment. We see quite often that sometimes, they're not really aware that there could be some medical payments coverage out there that would help cover the cost of the medical bills. Or maybe there's other health insurance. Quite often the patient may have commercial health insurance, but he's not volunteering it when he comes in because he feels like the other party should be paying all of his expenses. So it could be that there might be some other health insurance that could still be billed. Was there other insurance, meaning uninsured motorist coverage or underinsured motorist coverage, or maybe an umbrella policy, which would add additional collectability for the patient settlement. One of the ones that we see is missed most often is that the driver's policy is, someone is driving a vehicle that they don't own. So there's insurance on the vehicle that provides liability coverage, and then the driver, if they have their own automobile insurance, they could have excess liability coverage. So you might have, if they both have 25,000, 50,000, the minimum limits, you're looking at 50,000 instead of just 25,000. So the other standard that we like to apply is it reasonable? What we're asking for as far as compensation for the hospital lien out of the settlement? Is it reasonable? How would it look, if you were to read about it in the evening news? If you've got a patient that has a catastrophic injury and there's only $50,000 in coverage, and we've got a $300,000 bill, and there's hundreds of thousands of other coverage or medical expenses out there, sometimes the best option might be to have them complete your charity care applications, or you only expect a nominal amount on that to satisfy the lien. So maybe charity care should be an option in certain catastrophic cases, but it's just, can you justify the position, and can you, again, how would it look if you read about the case in the evening news? Would it reflect well in the hospital? So those are just some of the things that we like to consider when we're negotiating these liens. The other situation we run into is where hospitals are only filing liens on their high balance accounts. Usually the high balance accounts often have less opportunity for payment. So if you want a really good solid program, you want to increase your collections, you really want to be filing liens not just on your high balance, but on your other balances as well. Because when you do have a high balance account, there's probably a lot of other medical expenses beyond your own. So you could have competing liens. The patient injury is often more severe and disabling. So you'll have you may have wage loss and other factors that have to be paid out of the settlement proceeds. And when your minimum liability limits are only $25,000, that's not a lot of money to be dividing up among all these different medical providers and paying the attorney. So if you've got smaller balance accounts, those are often paid in full. And we often see most hospitals have a lot more accounts that are in the $2,000 to $5,000 amounts than they do six-figure accounts. So you want a lien program or an MVA program that's going to be looking at all balances, not just those high balances. Okay, the last area that we're going to talk about is when you are having good success, or you see the benefits of third-party liability collections, and you decide that you would much rather pursue that 70 to 80% collection amount than accepting the amount on some of your commercial insurance contracts. And we have always strongly recommended against this, because this is going to get you into hot water legally more so than any other practice that you could follow. This quite often will lead to class action litigation. We have seen this in areas across the country. I know Kyle's going to speak a little bit more about that in just a few minutes, but this is something that we definitely see. Either you'll end up in class action litigation, or you'll run into some unfavorable changes in your hospital lien statutes. We actually saw that, we had a client in Alabama that really wanted us to pursue third-party liability instead of filing with commercial payers. And we didn't want to do that. And so, we kind of ended up, parting ways as friends. However, we did see just a few months later, Alabama kind of took care of the matter, and they did make some changes in their hospital lien statutes to make it prohibitive to filing for third-party liability instead of filing with the commercial payers. Your collection percent from third-party liability could be lower than your commercial insurance rate, especially when you consider some of the things we've already talked about. When you've got minimal automobile liability coverage limits of $25,000, you've got a lot of bills to pay and attorneys to pay, and if the patient's not getting something in their pocket, they may not have any incentive to settle their case. So your collection percentage could be lower in a lot of situations than what you would get from third-party liability coverage. It also can have a negative impact on your AR days. Even if your recovery might be a little higher on third-party liability than filing it with your commercial payer, it's always better to get that payment, in 30 days as opposed to waiting, 365 days. So that is another factor that we really encourage facilities to consider. It's also important to coordinate the benefits appropriately. Now with Medicare and Medicaid, in Georgia, you can pursue third-party liability instead of filing with Medicare and Medicaid, but you do need to be careful if you're dealing with an HMO, because there could be some contractual language that could pose a problem. So you do want to be careful and try to avoid, having that either doing actions that are going to lead to maybe some adverse changes in the hospital lien statute, or that are going to get you involved in some of the class action litigation. So it's definitely important to stay on top of what's going on in your state in terms of what kind of cases are making their way through the courts and how those cases may be interpreting, the statutes differently than what we've been used to seeing. So now I'm going to turn it over to Kyle, and he's going to talk a little bit more specifically about some of the things that we've been seeing here in Georgia with regards to our third-party liability statutes and just some of the different legal trends.
All right, first I'm going to start with Georgia's hospital lien statute and get into some of the key specifics that you need to understand about Georgia's hospital lien statute if you're going to implement a motor vehicle accident program. The first thing is you have to make sure that you file your lien properly. There's two components to properly filing a lien in the state of Georgia. First, it has to be filed within 75 days of the patient's discharge. It also has to be filed in the correct county. First, it has to be filed in the county where the hospital is located, and if the patient lives in a different county, then it has to be filed in that county as well. Good news is if the patient resides out of state, then you only have to file the lien in the hospital's county. You don't have to figure out how to file liens in another state other than Georgia. The second key component is providing notice. Now notice you have to file the lien within 75 days of the patient's discharge, but you also have to send notice by certified first-class mail, return receipt requested, 15 days prior to filing the lien to the following people. You have to definitely send it to the patient. And then to the best of the hospital's knowledge, you have to send it to these two parties: the person that the patient claims is liable for the injury and the insurer of the person who the patient claims is liable for the injury. Now, if you're going to have a program, you need to show diligence in trying to ascertain the identity of the responsible party and their insurer. Some ways you can show diligence is by reaching out to the patient and asking the patient who hit you, who is their insurer, is there a claim number in the accident? And then from that claim number in the insurance company, you can ask them, who their insured is. You could also obtain the accident report. And these have been held to be adequate diligence in ascertaining the identity of these individuals. When you provide the notice, you also have to state that the lien is not a lien against the patient or any other property or assets of the patient and is not evidence of the patient's failure to pay a debt. If you do not comply with all of these provisions in the Georgia hospital lien statute, then your hospital lien will be invalid. Georgia courts strictly construe hospital lien statutes and failure to comply with these provisions against the hospital. So you need to make sure that your hospital lien complies with the Georgia hospital lien statute in every way. As Lori mentioned, you only have 1 year to sue to enforce your lien. So, and you don't, the patient does not have a responsibility to inform the hospital when they have actually settled their case. So you have to, following up, you can't file and forget, you must follow up to find out what that date is, because if you find out that the insurance company has paid the patient or the patient's attorney, you need to sue the insurance company who has the deep pockets if you have a valid lien. The fourth component is the filing fee. There was a very large increase in 2020 from $5 to $25 for filing a hospital lien in the state of Georgia. It has to be filed with the Superior Court of the county where you're filing it. And if the patient lives in a different county, then it's going to cost $50 to enforce your lien, to have an enforceable lien. And we have found that, based on our statistics, about 1/3 of the liens that we file are filed in both counties. Patient lives in a different county. Finally, the fifth component is the venue statute. Under Georgia law, hospitals may sue to enforce liens wherever an insurer has an agent. In fact, the venue statute says wherever an insurance company has an agent who sells insurance, then a plaintiff can sue the insurance company in that county. So we're located in Columbus, Georgia, Muskogee County, and most of the large auto carriers have an agent who sells insurance in Muskogee County. So it doesn't matter whether we have a hospital in Savannah or Augusta or Atlanta, we sue the insurance company in Muskogee County, and we make the personal injury attorney and the insurance company travel to Muskogee County so they can defend the lawsuit. And it really gives us a lot of leverage. Let's talk about some of the recent Georgia cases that have involved hospital liens. The first case, really good news, is Bowden versus Medical Center. In this case, the patient accused the hospital of fraud for filing liens at the charge master rates. Now, this case started as a discovery issue, and it only involved Ms. Bowden, who was treated at the medical center after a motor vehicle accident. And of course, the Georgia Supreme Court said that charge master rates and commercial rates are discoverable, and the hospitals have to provide these rates when they're being sued over the reasonableness of their charges. That case turned into a class action where Ms. Bowden represented a class, an unnamed class, undisclosed class of people who did not have health insurance but had hospital liens filed against them. And they all collectively were stating that it is an act of fraud when a hospital files a lien at charge master rates. This case was certified at the trial level. The Court of Appeals affirmed the class certification. And finally, the Georgia Supreme Court held as a matter of law that it is not fraud for a hospital to file a lien at charge master rates. To the collective sigh of relief for about 14 Georgia hospitals who were facing similar class actions. They also said that this case was not appropriate for a class action, so you couldn't have a class that, even though it's not fraud, patients can't come in and with a class action contest the reasonableness of the charges. However, they can still contest the reasonableness of the charges individually. And one of the ways you can combat this is, one of the ways that we do is we ask the personal injury attorney who is claiming that the charges are unreasonable, that our hospital customers' charges are unreasonable. I always ask them, what did you put in your demand? Did you tell the insurance company when you presented our bills that these bills are unreasonable? Or did you get paid full freight on the bills at the charge master rates? And I've been waiting for an attorney to interplead the funds so we can file that motion and litigate it, because I think that the Georgia Supreme Court would say that when a patient presents the bills at full charge and gets paid the bills that the charge master rates, then they cannot turn around and argue that those charges are unreasonable. Another case is the Kennestone line of cases involving the diligence required by a hospital to figure out who the tortfeasor and their insurers are. In Kennestone versus Travelers, Kennestone did not mail the tortfeasor a notice of intent prior to filing its hospital lien, and Travelers contested this and said that the lien was invalid because of that. Kennestone did not show steps to ascertain the identity of the tortfeasor, so the court held that the lien was invalid, and the Court of Appeals affirmed that. Now, in Kennestone versus Allstate, Kennestone filed a lien and sent the notice to the patient only before it filed its timely lien. Allstate came back and paid the proceeds to the personal injury attorney. Kennestone wasn't paid, so they sued Allstate. Allstate tried to use Travelers instead and say, well, you never sent the notice of the hospital lien to the tortfeasor. But Kennestone showed that it called the patient twice to search for the accident report twice, and the court held that that was plenty of diligence and that Kennestone's lien was valid. So having diligence in your program to investigate who is responsible for the accident and who their insurer is very important. As Lori mentioned, we are seeing a lot of states who are amending their hospital lien statute to require that hospitals bill commercial health insurance. I want to point out Colorado amended their statute in 2016. What happened in that case was a senator's child was injured and the hospital chose to not bill commercial health and instead try to get a higher rate of reimbursement from third-party liability. The senator drafted a bill very quickly, and it was rushed through the House and the Senate, and the state of Colorado passed this bill. And it really had even far worse measures. There's a question now whether or not you can actually file a lien when the patient has Medicaid or Medicare, whereas in all the other states, that's not an issue. And that is a very large issue in Colorado right now. You also have the discovery rules. Indiana, Georgia, and Texas have followed the battle line of reasoning that states that the hospital's commercial payer rates are discoverable when the hospital is trying to enforce its lien statute. And also, as Lori mentioned, we have recent class actions where hospitals are accused of fraud for filing liens in lieu of billing health. We have a couple cases in Texas. In Arkansas, Whitley versus Baptist Health was actually certified in 2019. We have a case in Alabama where the case was dismissed with prejudice against the named plaintiff, but without prejudice for uncertified class members. There was a problem with that particular class member. The important thing to note is, even if you win a class action, I could tell you, as having been a class action plaintiff's attorney, that the amount of attorney's fees are immense. The amount of attorney's fees that you pay to defend these class actions are going to be in the 6 to 7 digit range. And then if you lose, you're going to have to pay the plaintiff's attorney's fees as well. So even if you win, it's still going to be a very large expense. So you need to make sure that you're doing things right.
Right. You do want to have we've always felt we've had a conservative approach to TPL management, and you do want to make sure that whether you're doing it internally or you have someone else managing your program, that you are staying on top of all the cases that are making their way, not only through the courts in your own state, but that you're watching these issues as they cross the nation, because we see the same issues and the same items crop up everywhere. And we've seen the Bowden case referenced by a lot of these cases that are on this list. So, of course, the plaintiff attorneys, and they're all looking and watching, and they're tracking the same litigation. So they want to make sure that they know what's going on and what's being successful, and then they're going to try to replicate it in other areas. We've seen hospitals get hit with a lot of punitive damages and large fines. I know I think the Ochsner system in Louisiana had some large funds related to, an overzealous business partner handling their MBA program. So you do want to be careful. I mean, but I do think that kind of in summary, there are a lot of benefits to your bottom line from having a good MBA TPL process. There's also benefits in the patient experience, but you do want to manage it the right way. And you do want to make sure that you're staying on top of all the requirements and that you are, making sure you're monitoring your legal environment so that you don't get yourself into any risk areas. So I think that's the end of our presentation. I think we're right at time. So.
Yeah, we're right at time. We do have a few questions here. And so for those of you who can stick with us for a few minutes, I'll ask Lori and Kyle to give their answers. And then maybe, Lori, what we can do for those people who need to jump off is we can, I'll send you these questions and you can give me some short answers that I can include in the email follow-up on Friday.
Sure, I'd be happy to.
Okay, so the first question, does the patient's attorney have to disclose the amount the patient was compensated for pain and suffering separately from the settlement amount, or is it all inclusive?
It's typically all inclusive. When I can speak of it from the standpoint of the payer, when you're evaluating the claim, you're going to look at the medical bills, you're going to look at the treatment, and that's really, what you're going to base your evaluation on. And a lot of times they may mention if they feel like if I'm Allstate and I'm evaluating the claim and I feel like the charges were higher than usual and customary, I may use that in my negotiation comments back towards the attorney. And we've seen attorneys come back and say that if the payer disputed the charges, that's usually something that they'll mention in their negotiation with us.
Right.
And so you'll know that if that's an issue in terms of what they had to compromise or accept from a settlement amount. But they typically don't separate them that way a lot of times, unless that someone actually made that argument. And if the attorney tells us that, we're going to call that adjuster at Allstate and verify and ask them the basis for why they felt that. Because attorneys could tell you that all day long, but and maybe the payer really didn't, their auto insurance, that wasn't an argument that they made. But they don't normally tell you, they don't separate it that way to say, well, there was, $10,000 of medical bills, and then we got $5,000 in pain and suffering.
And I'll tell you, one of the unforeseen consequences of Bowden versus Medical Center was that insurance companies are now using, the patient's ability to contest the reasonableness of the charges. And now insurance companies are cramming down what they believe to be the reasonable amount of the charges. And we have attorneys that say, well, Allstate took your $10,000 in bills, and they said that really the reasonable value is what the hospital lists as their amounts generally billed, which would be 30 to 35% of the charges, and that's what we're seeing now, that insurance companies are trying to use Bowden in that way.
Most of your payers, especially your larger ones, are going to have a utilization and a charge review system on their end, and they're going to input your charges and the line items in there, and it's really going to tell them usual and customary based on the zip code area. So you do see that sometimes they're going to come back and they're going to try to refute that. Whenever we get that on maybe a med pay payment, or if we're dealing with the payer and trying to negotiate on the liability directly, we'll ask them to provide the basis of that, because how do we know that it's set appropriately or calibrated correctly for the area? And a lot of times when we push back on it, they back down. So, but we do see that sometimes, but it's not, they don't normally tell you that it's X amount for medical bills and X amount for pain and suffering, unless the attorney is alleging that they didn't accept all of the medical bills as either being related to the accident, or they felt they were higher than usual and customary. If you're getting that response from the attorney, you really should go back to the payer and verify that that was actually their position.
Okay. These next two questions relate to how to deal with this situation in the state of California. Here's the first question. Most auto med pay is paid to the attorney instead of the medical provider, and this is in California. How can this be tackled?
So we recommend that you have, one of the first things we do when we bring on a new client is we review their assignment of benefits language and their paperwork on their charity care programs and things like that. Is just kind of part of our service to make sure that everything you're using all the right verbiage and you're using everything that you have to your available to you to try to make sure that you're getting, that reimbursement. So a direction to pay that specifically references medical payments coverage would be appropriate in your state. And then that's something that I know for us, we then, when we're submitting the claim to the MedPay payer, we're going to attach that documentation to it and highlight it and point out to them that the patient agreed when they came in for treatment to assign those benefits, just like they would for, other insurances. So that was probably our primary recommendation for how to address that issue if you're seeing that problem with your claims.
In Georgia, there's a case, Thomas v. McClure, that says that a hospital lien is enforceable against underinsured or uninsured motorist coverage. In Alabama, and basically first party coverage, in Alabama, very similar statute, a different court case states that a hospital lien is valid against MedPay. And so, but there isn't a Alabama case that said that a hospital lien is valid against nor is there a Georgia case that says that a hospital lien is valid against medical payments. But I would look at and see if under California law, if a hospital lien is valid against medical payments coverage in the state of California, or if it kind of mirrors Alabama and Georgia. And if that's the case, then you could send a copy of the lien to the first party carrier, the MedPay carrier, and get payment.
Yeah, we see, I know in some of the areas in California where we have clients, we see a lot of excess MedPay. So it's coming in after the commercial health and picking up on deductibles and copays. But we have worked and been successful with just making sure that the assignment of benefits language includes that direction to pay. So hopefully that'll be helpful for you.
And with California, MedPay is probably a little bit more important because of the limitations they have on
the liens.
On the liens, you can only collect 50% after all other liens have been paid, which kind of infers attorney's liens. So really, the most you're going to get on it if the patient has or the liable party has a minimal limits $15,000 policy is $5,000. So getting at that first party coverage in California is really important.
Right. And we thought Georgia was low at 25,000, but California is 15. So you're limited. You're usually looking at maybe $5,000 as your maximum reimbursement on some of those cases.
Okay. Next question. Attorneys request medical bills but want providers to bill the patient's medical insurance, Medicare, commercial, or Medicaid. Again, this is in California. How would you counter this?
Well, the patient or the attorney is going to want the medical bills. They're going to need them to support the patient's damages. And they do want, they can ask or try to insist that you bill Medicare, Medicaid, but the provider is not required to do that. And the reason they want them to do that is because if your bill is $10,000 and you file that same bill with Medicare, maybe you're going to get reimbursed $2,400. I'm just going based on rough averages. And then the attorney's going to have to pay Medicare, so he's going to have to pay their subrogation claim when he settles the claim, but he's only paying $2,400 as opposed to paying $10,000. So that's why the attorneys want that. You do have to provide the medical records, and you do need to bill the commercial insurances or any HMO that has a hold harmless provision in the contract. But straight Medicare, Medicaid, it is the provider's choice. I know that is the case for Medicare. I believe for Medicaid in California as well, that is the provider's option. You can't do both. You can't file with Medicare, Medicaid and file your lien. And then once you get your lien, your case settled, refund Medicare, Medicaid. You can't do that. But if you decide up front you're going to pursue third-party liability in lieu of Medicare and Medicaid, that is the provider's option in California. So we deal with that quite frequently. We have the conversations with the attorneys and let them know that, and we sometimes, if they want medical bills or copies, we can provide that to them. They do need that documentation, and the patient is entitled to it. But as far as what happens, as far as with regards to who gets billed, they can't force you to bill Medicare instead of filing a lien.
And if the questioner is concerned that the personal injury attorney is getting a bill at full freight and submitting it for payment, yet requesting that the hospital bill Medicare and Medicaid at a lower rate, or commercial health, in fact, there's a thing called the collateral source doctrine, and in a court case, it's very complex, but in a court case, the jury is going to see what the charge master rates are, even if the patient has health insurance and the hospital is actually only reimbursed at a far lower rate. That's the collateral source doctrine, and it's because the patient has paid premiums, and the responsible party should not benefit from the patient having insurance. And that it's probably not a good way to explain the unfairness of how that appears for the hospital, but it's something that the hospital just needs to know that they need to build commercial health.
But that is kind of the argument we're relying on when they're trying to say that it's fraud to file your lien at the total bill charge. Well, they're also using the total bill charge to try to make sure that they're maximizing the recovery on the settlement. So, you can't have it both ways. So, yeah.
Okay. The last here is a comment, really more than a question. Good comment on charge master rates. Attorneys always want full charge master rates on the bills, but don't want to pay this amount to the provider, instead pay Medicare or Medicaid rates. So I think that just kind of falls along what you just said.
Yeah, I think we all feel very strongly the same way. And I think some of the comments actually in the Bowden case, if you read the judge's comments, they're sort of, going down that path as well, which is why we think if we get the right case on an interpleader action where, they're arguing a reasonableness of charges, but they submitted the full charges in their demand settlement, that's kind of what we're hoping for, but everybody keeps backing down. So.
And it's important too, if you do get a discovery request, asking for other health insurers, or if you get deposed in a case, the attorneys always want to know, well, what is Medicare? What would Medicare reimburse you for the same procedures, or Medicaid, or Blue Cross Blue Shield, or Humana? My advice is to not just limit yourself to those carriers, but find the highest reimbursement rate with a commercial carrier that you have with one of your contracts, and testify about that. I mean, if you've got, a 7% discount off charge master rates, use that contract, because that company certainly isn't commercially unreasonable. And then you have a patient who doesn't have health insurance, and they're trying to get in on that contract. Well, they haven't paid a dime in premiums, and they shouldn't receive the benefit because there's no economies of scale with an individual patient.
Right. So, and we try to help our clients to, if they do get in a situation. We just had a few instances where, there's a discovery request about that. So we try to make sure that the answers are appropriate, and they're putting everything in the best light possible.
Okay. Well, listen, lots of great information, and thank you everybody who we were able to stay on with us for this. Again, Lori and Kyle, thanks so much for sharing your expertise. Our last webinar of this year will be December 9th. It's Leveraging Your Physician Advisor. And we'll be picking up again in January with an HFMA Region 5 webinar day. We're coordinating for that date now, so please be on the lookout for details coming in the next few weeks. Again, thanks for joining us today. Have a great Thanksgiving holiday. And here's hoping all of us on our Zoom family dinners that works well and we don't have technical difficulties. Thanks again.
Thanks, Laura.
Yep.